Senzo Meyiwa trial update, van accident and waived medical exam. Good evening and welcome back to my channel. I am Skybridge. Today, inside the Pretoria High Court, one of the accused in the Senzo Meyiwa murder trial was involved in a vehicle collision, yet insisted on continuing without an immediate medical exam. Stay tuned to hear how Judge Ratha navigated that waiver and what this means for justice in South Africa. This morning, as the trial reconvened, the transport van carrying accused number 4, Maphisa, was involved in a minor collision at the intersection of Kosi Mampuru and Nanasida streets in Pretoria. Correctional Services protocol requires any prisoner in an accident to undergo a medical examination before returning to court. Judge Mokoatlheng asked whether Maphisa sustained any injuries. Both State Prosecutor George Baloyi and Defense Advocate Zithulele Nxumalo confirmed the accident was not serious and that Maphisa felt unscathed. The judge then explained that Maphisa still had the right to request an adjournment for a thorough medical check, even if symptoms could appear later. But what does it mean legally? By waiving his immediate medical exam, Maphisa effectively accepted any future complications, could not halt these proceedings. Legally, that waiver doesn't prevent him from claiming damages against the state years down the line, should latent injuries emerge. But for the trial, it signals his readiness to push ahead without delay. Transparency in high-profile trials like this is crucial. The public has a right to follow every step, from unexpected accidents to procedural waivers. We invite you to engage responsibly, share verified updates, discuss the implications for justice reform, and hold our institutions to account. Thanks for watching. If you found this update insightful, hit like and subscribe, and ring the bell so you never miss a courtroom briefing. Check out our previous deep dive into the Section 174 discharge application here, previous video, and stay tuned for tomorrow's segment on the defense case. Throughout our coverage, we'll continue to bring you live courtroom takeaways, legal context, and civic hooks that empower you to be an informed participant in South Africa's pursuit of justice.
Makes it spontaneously. I was not there. I was in Natal. I was incarcerated. Fine. But then he pleads not guilty, right? And he chooses not to give a plea explanation. And before the plea stage, the law is very clear. They say there's no legal effect of that statement. I know Himstra says there is, State versus Nkotle. Have you read that decision?
Yes.
I'm going to quote it some other time.
Yes.
Himstra says, but he refers to after the plea. He says anything said by counsel and by an accused person after the plea, the court must take that into consideration.
Yes, that might be so, but
yeah,
we suppose nothing debars a cross-examiner to
nothing
on that aspect.
Nothing, yeah.
Yes.
Nothing, yeah.
But
I'm just saying,
whole point.
There's no legal effects.
Yes.
On the basis that you can attribute guilt to a person who is not saying anything under oath, having pleaded.
Yes.
If he has pleaded, that's different. Okay, fine. Yeah, you heard me.
But just before we proceed, my lord, we informed that this morning, when accused number 4 was being transported to court, the vehicle wherein he was being transported was involved in a collision at the corners of Kosi Mampuru and Nanasida streets. His counsel says he's fine to proceed for today, but Correctional Services indicated that their normal procedure is if there's such an accident that the prisoner must be taken for medical examination. And that entails accused number 4 is incarcerated at Leeuwkop.
Yeah.
That entails him being driven back to Leeuwkop to be booked out and then taken to a medical facility. We just thought we should bring it to the attention of the court.
Does it claim or allege that he was not injured?
Well, that's what you say. He was unscathed, but yeah, as I say, correctional services officials say in terms of their rules,
Yeah, the rules, fine.
they have, such a person must undergo medical
Yeah, no, fine, you're
attention.
right,
And
because-
we know that in any collision,
Yeah,
there might be whiplashes
That's
which
it.
manifest at a later stage. So perhaps ex abundante cautela, it might be wise to have him subjected to medical examination.
I'm in your hands. So what do you suggest? We adjourn.
I think it's a call that must be made by Advocate Numalo, Malot.
No, no, no. In terms of the law, that is the position. But the law is very funny. You can waive the law. He's the only one who can waive that right to say, I appreciate and I know that after such an exigency, I'm entitled in terms of the law to be examined, and I insist that I should be so examined. But he can say, well, I waive the right to do that. But I don't encourage him to do that. I'm just saying a right can be waived.
Yes. Yeah, the only problem is if one
Yeah,
is
yeah.
not trained in the field of medicine,
Yeah, then he'll say, hey,
difficult
it
to-
was, what
to
do they
waive
call
it.
those injuries?
the whiplashes.
Yeah, no, they use a word for that, which are not apparent.
Latent
Latent.
injuries, yes. Yeah.
I know lawyers who do RAF. A guy, they allege he was involved in an accident. After 6 years, they say, this guy, he can't even stretch his hand.
Yes.
So what do we do? Who's the counsel for Mr. What do we do?
He says it's fine, my lord, but I think one has to be cautious because, something might happen, he might feel well, but later on, only to find that...
How was the accident? Severe.
No,
Are they
no,
saying they're
not
going to
severe.
investigate the accident?
No,
Nobody's talking about that.
No, it was not a serious accident because only the front part of the van was damaged, the bumper. But he
Is it?
says he's fine. I wouldn't encourage my
No,
lord
no,
that
no, no.
we...
He must formally waive his rights. Otherwise, I'll be said to be not compliant with the law. So I'm in your hands.
Let me approach him for the last
Yeah,
time.
fine.
Thank you.
Fine. But in the meantime, we can go on with the interpretation. And after that, our colleague there can decide whether he wants to be examined immediately or not. So what, you want us to adjourn? I can adjourn.
Thank you, my lord, for the court's indulgence. He says it's fine, we can proceed. He has waived his right.
Yeah. It must be formally done. I remember what one of your colleagues said. They haven't told us about our rights on the 27th of July. You remember that statement?
Yes, indeed.
Abasitshelanga amalungelo ethu mana nabo bathi basibopha. So what do you want to do, sir? Me, I'm in your hands. If you say he wants a day to be attended to and be given a medical certificate to say nothing wrong with him, fine. We
My
can
lord,
adjourn.
I've just indicated that he says we can proceed, it's fine.
Sir, are you sure?
Bafokothi nesiqiniseko sokuthi ngempela sakhe singaqhuba ngohlelo lwanamuhla. Yes, my lord.
And
I
you
am fine.
appreciate you've got rights not to continue, but to insist that you must be taken to a medical attendant.
Bathi unalo ke ilungelo ukuthi simise kancane ke ngohlelo lwanamuhla loqhuba la enkantolo ke kuze fika isikhathi la uhamba khona ke uhlangana khona ke nabadokotela bathi ukuhlola kancane. Right, Baf. I am fine, my lord.
I can tell you this. It doesn't mean that in 20 years' time, when you believe that you had a latent fracture, you can't sue the government, okay? It just means you can go on today. It doesn't extinguish your claim, because you are not extinguishing your claim. You are basically saying you are able to go on because at the state at which you are, physically you think you are able to go on. Okay, does he understand it? Just explain.
Athi lokho kusho ukuthi ke ngemuva kweminyaka ke engamashumi amabili ke uma ungabe ungasele ungazizwa kahle ke esimeni sakho sempilo lokho kuyakuvimba ukuthi ufake ke icala malana nombuso ke lapho ke athi lokho ungakwenza ke futhi unenkululeko yokuthi lokho ungakwenza yezwa ke ekwambeni kwesikhathi ngabe lokho kuyakuhlupha ke.
Okay.